A very warm welcome to Law and Life. Today, I, Shashank Mishra, as the host, will be having the conversation with Senior Advocate of the Supreme Court of India on the issue Hijab Imbroglio. Good morning, sir. We will be starting this session, and let's start with the first question. In the aftermath of judgment of the Karnataka High Court in Hijab case, death threat have been issued to the three honorable judges who gave the verdict, and they had given wide security by the state government of Karnataka. What is your comment on that?
Good morning, Shashank. Uh, Death threats to the honorable judges is condemnable in the strongest terms. Organizations sending out such threats want to destroy the rule of law in our country. Use of small children to convey such death threats is most despicable. Those responsible for such acts must be dealt with utmost severity. It is much more than just an ordinary case of contempt of court. I want to emphasize that the judgment of the Karnataka High Court is a unanimous verdict. All the three honorable judges, that is Chief Justice Mr. Justice Rituraj Avasthi, Justice Krishna S. Dikshit, and Miss Justice Zaibunissa M. Qazi, have given a unanimous verdict. They started hearing the case at the earliest after the writ petition was filed and referred to the full bench. Continuous day-to-day hearing was given. Every aspect of the case has been considered. 130-page judgment has been delivered in record time. The judgment has considered and copiously quoted from the Holy Quran. It has also considered more than 90 authorities, which are judgments of our own Supreme Court and the High Courts, and foreign judgments of the House of Lords, the US Supreme Court, and the apex courts of South Africa and Malaysia, apart from the international conventions. Within a day of the delivery of judgment, matter has been mentioned in the Supreme Court for listing the specially petition challenging the judgment. Such alacrity can happen only in India. Uh, since the Supreme Court is seized of the matter, I will refrain from making any comment. But I can give facts and information bearing on this issue.
Sir, can you in a nutshell tell us what has been held in this judgment?
Yes, the judges at the end of discussion of each point have given their conclusions. After consideration of every aspect of the matter, the full bench has held. Number one, that wearing hijab is not an essential religious practice of Islam, and hence it is not protected by Article 25 of the Constitution, as per several judgments on the subject delivered by the Supreme Court, which are binding on the High Court. The second thing which the judgment has held is that prescription of school uniform is not violation of petitioner's fundamental rights under Articles 19(1)(a) and 21 of the Constitution. And thirdly, government order dated 5th of February 2022, which was impugned by the petitioners, is not arbitrary, nor does it violate Articles 14 and 15 of the Constitution. These are the three conclusions of the judgment.
Totally affirming on the above statement led me to raise next question. When hearing is so speedy and judgment is given on such detailed consideration of all aspects of the case, why death threats is to the honorable judges? They have only performed their constitutional duty. The aggrieved have indeed moved to the Supreme Court for a special leave to appeal. What wrong have the judges caused, sir?
You are right. There does seem to be something more than what meets the eye. Let us look at the issue with the highest degree of objectivity. Hijab is not even worn by any student in any concerned educational institution ever since these institutions were founded. No such right was ever asserted till now. How come that suddenly all these students en masse started wearing hijab this year? Therefore, where was the cause of action to go to the court? The High Court has applied the essentiality test enunciated by the Supreme Court in various judgments to hold that wearing of hijab is not essential to the religion of Islam. Those are all constitutional bench and smaller bench judgments which are binding on the High Court under Article 141 of the Constitution. I may in this connection add that there is nothing specific about the veil to connect it to either the Arabs or the religion of Islam. Veils were being worn by high status women in West Asia and Europe before the advent of Islam. As a matter of fact, the Prophet has himself laid down what is essential to Islam. Those are called five pillars of Islam, and they are number one, Shahada, that is foundational belief of Islam that God, Allah, is one and Muhammad is his messenger. Number two, Salaha, that is offering namaz, that is prayers 5 times a day. Number three, Zakat, that is giving by every Muslim 1/6 of his income to charities. Number four, Swam, that is fasting during the Hijri month of Ramzan. And fifth, Hajj, pilgrimage to Makkah and Medina. The Prophet further ordained that what really distinguishes a Muslim from others is the first pillar, because in certain circumstances it may not be possible for even a religious Muslim to perform, let us say, uh, offering of namaz every day. Someone may be sick. Zakat, he may not be able to perform because he may not be in a position to give sixth part of his income to charities, or during the Hijri month of Ramzan, he may not be able to fast due to illness or any other, or he may not be able to go to pilgrimage, that is Hajj, in his lifetime. So, what the Prophet has ordained is that only the first pillar is essential feature of Islam. How can petitioners or anyone else, add anything more than what the Prophet has himself ordained? This is my question.
So, but these are not the consideration for the court, sir.
Why not? In fact, these are far more relevant for a meaningful decision. Before the advent of Islamic fundamentalism in Islamic countries, in the wake of Soviet-Afghan war, the veil that is called, abaya, burqa, chador, gosha, hijab, and different types of veil were banned in most of the Muslim countries. This was mostly due to the lead given by Mustafa Kemal Pasha, the founder of the Turkish Republic, who abolished Khilafat or Caliphate in Turkey. It was a tacit recognition that Muslim women have to wear the veil under extreme pressure from the clerics. In those days, that is early 30s, in Central Asian republics of former USSR, systematic campaigns were carried out against the veil. The Turkish Supreme Court itself has struck down the law removing the ban on the veil. New law had to be passed in 2010 to lift the ban on veil. Total ban on veil is still in force in Muslim countries of Tunisia and Tajikistan. North African countries like Algeria, Egypt, Libya, Morocco, Sudan do not require Muslim women to wear veil. Now even Saudi Arabia does not make it compulsory. In Central Asian countries like Azerbaijan, Kazakhstan, Turkmenistan and Uzbekistan, wearing of veil is not insisted on. So is the case in Indonesia and Malaysia. You see, only in obscurantist countries like Pakistan and after the seizure of power by the Taliban in Afghanistan, veil is compulsory. Without doubt, veil in any form creates an obstruction in rapid identification of an individual at the airport, railway stations, ports, bus terminals, election booths, delivery of goods and services to say by the state, to mention only a few. These are probably the reason why veil in any form is banned in many countries of Europe. Austria, Belgium, Bulgaria, Denmark, France, Latvia, all of them ban the wearing of veil. As a matter of fact, the European Court of Justice has upheld the law banning the wearing of any religious symbol, including hijab. Amongst Iranian women, sentiment against veil is very particularly strong. Every year, numerous demonstrations are publicly held, tearing and burning of veil. In this case, in this connection, I may recall that UN Human Rights Commission has had to call upon the authorities in Iran to protect not only anti-hijab protesters but their lawyers also. Why should our constitutional courts be compelled to waste time on such untenable issues? This brings me to the story of struggle of our own Muslim sisters against what in Hyderabad is called Gosha and other and in other parts of the country called Burkha. See, in mid 1990s, Salma Mahmood, a feminist Islamic scholar and founder of the organization called Majlis-e-Ittihad al-Khawatin ul-Muslimin Hind, Al-Khawatin to be short, submitted a memorandum to the then Prime Minister Mr. Narasimha Rao that, and all the chief ministers, in which she stated that her organization proposed to hold a Mujahira-e-Burkha Fash wherein Al-Khawatin activists wanted to assemble in the city square of every state capital and publicly burn the veils. They believe that veil is the symbol of slavery of Indian Muslim women and root cause of their backwardness. But neither Prime Minister nor any Chief Minister of a single state, including the women Chief Ministers of Tamil Nadu, that is Miss Jai Lalita, and Uttar Pradesh Chief Minister Mayawati, uh, gave any helping hand to these women. And that's it. In our own times, the hijab was promoted amongst Muslim women living abroad and wearing Western attire by the Pakistan's military dictator Ziaul Haq. He is also responsible for so many other atrocious things, like amendment to his own country's constitution, setting up federal Sharia courts in which only Muslim judges, Muslim ulemas, Muslim lawyers, and Muslim alims can participate. No non Muslim is allowed in any capacity, either as judge or counsel. But he had no power to make such amendment. But you see, no, these amendments which were made in the constitution, which the military dictator had no power to do, but no party in Pakistan has, I would say, courage to uh, deny those constitutional amendments. But I think we'll have to hold a discussion like this on those aspects later. India is not an Islamic theocracy governed by Sharia. Therefore, every trivial Islamic belief or practice cannot be made enforceable. What is done in regard to hijab by other countries, especially those not governed by strict Islamic laws, is definitely relevant for our purpose.